Okay, I'm going to record this again, but I'm having, this has been crazy. My audio's been just beating me up here today. Okay, so here we go. Say like that. We're going to exit that. We're going to exit that. I don't need to do that. And Senate Bill number 1. There's my video audio. It's recording. Good. I see sound happening. And we'll see if my radio audio is kicking in here. It's not. For some reason, my audio for my Audacity thing is not happening. Okay, hold on. I'm gonna stop. I'm gonna get rid of that. But normally, what I'm supposed to do right now, and for the video audience, is I'm supposed to actually be able to hear my the sound kick in that is the radio bumper music, what they call it, the bed, right? So maybe I'll just go like this and say like that. See what happens. And this is not supposed to be ringing. Hello? Oh my goodness. Oh boy. Not supposed to be happening. Everything's going bad right now. And you got it on video. We're getting it live streaming. Live streaming of everything going wrong. So this was supposed to be on silence. And my radio audio, my file itself is supposed to be playing right now. And what you guys normally hear, am I going to have to play my own harmonica? But I'm going to have trouble monitoring my audio. Normally I hear the music coming in, and I can be reading from Senate Bill 1 at the same time that I'm able to audio setup, host, playback device. Let's see what it says. Speakers. All right, speakers. Share audio. No, we don't want to do that. Okay, I'm just going to go ahead and go with this. And let's see what it does. Record meter, start monitoring, testing 1, 2, 3. All right, playback. It'd be really nice. Oh, I know. Here it is. Playback level. Here's our problem. Playback level. Okay, we'll go like that. See what happens. All right. Sorry for the weird non-professionalism, but it is what it is. So let's go ahead and go for it. Fellow Freedom fans, David Allen Carmichael, Preservative Talk Radio, engaging the issues of the day on a constitutional basis, a biblical basis, the basis of right versus wrong. I'm going to go ahead and go to Senate Bill 1 of Tennessee statutes that's going to be effective July 1st of this year, unless, of course, the United States District Court, I don't think they could do it. I think our government's in some serious trouble if this law goes into, gets held up by United States court. And the reason why is because it's pretty big reach of the United States government to reach across the separation of powers in contradiction to the 10th Amendment to say a state can't enact a statute and carry it into force. So, and the other thing is, okay, let's go ahead and we're going to look at Senate Bill number 1. And then, so you'll be able to kind of like see it for yourself. What does the statute say? Has the Tennessee legislature lost their minds, or are they acting according to sound discretion and doing that which is the appropriate police power of government to protect the least of these from the insults and injuries of the stronger ones in our society. So here's Senate Bill 1, finding. Now this is important because the Tennessee, they know they're going to be sued on this. So they have to explain that the rationale for their conduct. Was it arbitrary? Was it just this flippant thing? Are they just trying to be mean to people and steal their rights? Or what is their purpose? So here's what it says. The legislature declares that it must take action to protect the health and welfare of minors. Oh, that is a no-brainer. We talked about that, fully. So they have a duty to protect minors, who are the least of these, from the insults and injuries of others. The legislature determines that medical procedures that alter a minor's hormonal balance, remove a minor's sex organs, or otherwise change a minor's physical appearance are harmful to a minor when these medical procedures are performed for the purpose of enabling a minor to identify with or live as a purported identity inconsistent with a minor's sex, or treating purported discomfort or distress from a discordance between the minor's sex and asserted identity. Already, me not being an expert, I'd like to slap whoever wrote this. I think it's not written right. It's written badly, because it gives fuel to the fire to those who say, oh, you're just targeting, you're just anti-transgender. In my mind, I would have said the medical procedures that alter a minor's hormonal balance, remove a minor's sex, or, leaving that out of the picture. But even giving treatment for a minor's hormonal balance, if you have to say what the purpose of even a legal treatment, what would make it lawful? What would it be permissible? In fact, I would think by nature it is presumed to be against the law to alter a minor's hormonal balance, no matter who you are. Not just because it's a dysphoria issue, but it needs to be established that a minor's hormonal balance, a minor's health, removing a minor's sex organs, or changing a minor's physical appearance are harmful to a minor unless, it would have to say unless, not particularly for, but what would be the exception to it? Would a circumcision constitute a minor's physical appearance? Absolutely. So it seems to me this thing should be written in such a way that you're saying what's prohibited with the following exceptions. And then you have a rational exception. Now, if one of those exceptions would not be because they're in a dysphoria. Dysphoria does not count. We could talk about a 3,500-year-old tradition, or no, what's it, 4,000-year-old tradition of circumcision, or whatever it is. Obviously there has to be there. It's a permission. But I would think that this thing should be written absolutely as a protection of minors, and somebody ought to be slapped. I'm sure, but their motivation was great. But I think this probably should have been written from a different perspective. But this is what it says. It determines that medical procedures that alter a minor's hormonal balance, remove a minor's sex organs, or otherwise change a minor's physical appearance are harmful to a minor when these medical procedures are performed for the purpose of enabling a minor to identify with or live as purported identity inconsistent with the minor's sex, or treated purported discomfort or distress from discordance between the minor's sex and asserted identity. I think I've made a better argument on my radio show, is that dysphoria does not justify maiming. We could have saved a lot of words there. Dysphoria cannot justify maiming. It's not in the statute in those words. These procedures can lead to the minor becoming irreversibly sterile. True. Compelling interest of the state there. Protect a minor from becoming irreversibly sterile when they should be at a time being protected from their own dementia. Having increased risk of disease and illness or suffering from adverse, sometimes fatal psychological consequences. Moreover, the legislature finds it likely that not all harmful effects associated with these types of medical procedures when performed on a minor are yet fully known. So there's, again, this is going to be debated. They're going to get all these subject matter experts, but if they leave the foundation of what I talked about earlier with Blackstone's commentaries on the law and what rights people have, the principle, the history of when we were in our sound minds and determine what is lawful, if they would stick with that and keep everything within those bounds, notwithstanding somebody's wanting to mutilate themselves because of their dysphoria, it's just not permissible. Bless your heart. I understand you feel like you're not satisfied with your current situation, but you're not allowed, honey, to mutilate yourself. You just can't do it. You've got to wait till you're 18 and you're free to do the wrong thing because you stepped out of the protection of your parents or your guardian. Bless your heart. So that's what we're dealing with. Moreover, okay, so let's keep on going. Now, this goes on to another paragraph. Legislature determines that there is evidence that medical procedures that alter a minor's hormonal balance, remove a minor's sex organs, or otherwise change a minor's physical appearance are not consistent with professional medical standards. Now, the legislature is making a medical decision here. That's a little bit awkward. I think that's on shaky ground. I really wish they had contacted me and I'd counsel them on the writing of their statutes. So, but the thing is, it comes down to if it's for the purpose of minor to identify with or live as a purported identity inconsistent with the minor's sex or et cetera, et cetera, et cetera, for treating discomfort as distress from dysphoria or whatever, then it's a problem. And again, I think it could have been written better of saying you're not allowed to mutilate minors with the following exception. And if the exceptions are limited to physical, as they said, a dysformity or a congenital disease or some kind of thing that is already a mutilation. If you're going to do a plastic surgery on a physical mutilation that is already there by nature, then that would be the legislature carving out an exception to the absolute that you do not alter hormonal balance, physical genitalia or whatever, for a minor. It should just be absolutely prohibited with certain exceptions. The legislature finds that, and here, I'm not even going to read it. They kind of throw some doctor under the bus from Johns Hopkins University. A Johns Hopkins doctor actually tried to throw me under the bus one time in a naval exercise. It backfired, so that's for another day to tell you. It's kind of entertaining. But so they kind of throw some guy under the bus saying this doctor does all this like crazy stuff, Dr. Mengele or whatever his name is. The legislature finds that minors lack the maturity to fully understand and appreciate the life-altering consequences of such procedures. Now, legislature finds, how about the legislature recognizes for time immemorial the reasonable observation that minors lack the maturity to fully understand and appreciate life-altering consequences of any procedures. And many individuals express regret for medical procedures that were performed on or administered to them for such purposes when they were minors. So these are the kind of the observations of those legislators. And then let's see. Oh, watch this. This is throwing somebody else under the bus. The legislature finds that many of the same pharmaceutical companies that contributed to the opioid epidemic have sought to profit from the administration of drugs or the use of devices on minors for such purposes and have paid consulting fees to physicians who then advocate for administering of drugs or use of such devices for such purposes. So the first half of this statement I think is irrelevant, but the point where they get to these organizations, these businesses that have a profit motive are paying consulting fees. They're paying the physicians, besides what the patient pays them. They're paying the physicians extra money. It's gratuitous there. So The legislature finds that healthcare providers in this state have sought to perform such surgeries on minors because the surgeries make a lot of money and huge money makers. It's quoting doctors here because these are statements in quotes, not necessarily because the surgeries are in the minor's best interest. So in regulating commerce and the morality of commerce, that is a legitimate interest of the legislature. They also find that they have threatened employees for conscientiously objecting for religious, moral, or ethical reasons to performing or administering such medical procedures. That's a legitimate interest of government. So what we're going to find here is there may be items in this statute, Senate Bill 1 that passed, is that will be found to be unconstitutional in that they're arbitrary, they're not sound. It's not a legitimate purpose of government, of legislation. But there's a place down here, and I checked it, there's a severability clause at the end, which says if any of these items that we've listed here have been found to be not consistent with the Constitution or whatever, it doesn't make every other word bad. So every other word that is not carved out by a finding of fact and conclusion of law, every other word is in full force. So that was a smart move, highly recommended. And then he goes on, let's see, he threw somebody else under the bus here. The legislature, now this is sick. Again, it just shows you the dementia of these people who would like to mutilate children. The legislature finds that healthcare providers in this state have posted pictures of naked minors online to advertise such surgeries. That's profane. Now, there should be a law against that. See, write the statute that punishes the conduct. The legislature finds that now they're throwing Planned Parenthood of Tennessee and North Mississippi, an organization responsible for killing tens of millions of unborn children, has become one of the largest administrators in the state of such medical procedures. Now, in a rational mind, objective look at things, whether it's Planned Parenthood or any other profane institution, I don't know that that's relevant in particular to the statute. Okay? Now, we have found that organizations such as Planned Parenthood or whatever are in the business of a propensity to kill and maim, which are, as we read Blackstone, are those rights that are absolute, that no authority can kill or maim a human being. That's a natural right that they have for their self-survival. That's an absolute right given from God. So I'm going to come back. We're going to take a break from this, breathe a little bit, and we're going to review this statute again. I've got a few more items that are highlighted here. My goal is to let you know, the listener, you're going to be the ones who are ahead of the curve on this. You're going to hear all kinds of rhetoric from news people and stuff like that, but you're going to know the truth. You're going to know what the complaint says. You're going to know what the statute says, and you're going to know the right or wrong of it from a very reliable source. So we'll be right back with our Preservative Talk Radio. So what I'm doing right now is I'm just checking to see if my video stream is functioning, and then because I've got a 2-minute audio break here, and then I'm going to get right back to it. And if I had some chat going on, somebody could tell me that everything was kosher. Yeah, it looks like it's set up well. So now what I'm going to do, this is kind of hard. This is kind of hard just for video people. Like and subscribe. You know, I don't have likes and subscribes. I need some likes and subscribes. I think more people ought to see this. I've got a radio audience. It's true. You know, so many thousands of people listening it for 3 minutes or every 3-minute period, whatever the stats are. But this is actually a very difficult thing. So I had to do a lot of reading, and then to try to get it to palatable for a you know, kind of the sitting back in the pew entertainment folks, and get the substance that's necessary. So, and this is a very difficult subject. So I'm going to do my best. And I've got 2 more segments. So it's 30 minutes of monologue. And so right now we're in our 2-minute break period. So because I was having trouble with my audio before, probably because I skipped ahead, and I think I messed up my audio recording software. And I don't know if you can hear the dog in the background. It's a police dog. All right. We're almost there. Got about 15 seconds. Fellow Freedom fans, David Allen Carmichael, Preservative Talk Radio, with this Faith and Preservative Talk Radio. We're talking about Senate Bill 1, and I'm a little distracted here as I'm trying to plug through all of the details of this thing. This is kind of a difficult subject, but I think it's very important. This matters. Your next generation. You don't want to be in a situation where you're having to recoil in the next generation from what's been happening right now. It's possible that the lunacy, I don't know. Actually, I have no way of proving this, but it's possible. I'm hoping. I have hope. I'm maybe naively thinking that the lunacy that we're facing, the absolute pandemic of dementia that's sweeping North America, is going to fade, just like COVID. The effects of COVID are fading as our bodies are healing. Maybe this pandemic of dementia will pass us by, and that we can reorient and start doing those things that make sense. So what I'm going to do now is let's go back to Senate Bill 1, and I'm going to tell you what this bill says. And then, of course, you are the customer. You're the one who is supposed to be the one for whom the legislature serves. So, customer, here's the product that your legislature is giving you. In Senate Bill 1, one of the concerns that they laid out was the state has a legitimate, substantial, and compelling interest, good language, in protecting minors from physical and emotional harm. You could have saved so many words just to say that right there. It was beautiful. And they have the same interest to develop, give the ability of minors to develop into adults who can create children of their own. Procreation is a legitimate survival interest of society, unless you're into genocide. It has a compelling interest in promoting the dignity of minors. And of course, their opposition, the United States Department of Justice, might say, well, that's what their interest is as well. They want to encourage minors to appreciate their sex, particularly as they undergo puberty. Now, I talked about that there's dysphoria and there's discouragement, there's depression, there's all kinds of things. And intervention is so desperately needed for our teenagers by their parents or guardians, whoever it is that has the closest blood relative or person of interest who has the greatest natural love for them to promote their health and wellness. So they also have a interest, the government has interest in protecting the integrity of the medical profession. That's true. We talked about that earlier. Against doing procedures that are harmful, unethical, immoral, experimental, or unsupported by high quality of long-term studies, or it might encourage minors to become disdainful of their sex. Now, here's something I put in a separate color. It's green. Let's see what it says. This was my throw somebody under the bus color. Let's see. Procedures from being performed on minors when the purpose of the procedure is to enable a minor to identify with or live as a purported identity inconsistent with a minor's sex. Again, the words they're using there, I would say that it does not justify an exception to the absolute rule that minors need to be protected in their body, to not be maimed, to not be challenging their life, or the life of their next gen or their posterity, that their exception to any surgery does not include dysphoria. So they said here that they can't use the procedure to treat purported discomfort or distress from discordance between the minor sex and asserted identity. Now, of course, it's supposed to be in the context of hormone blockers or promoters or whatever. And then they go on to define a congenital defect. A congenital defect means a physical or chemical abnormality present in a minor that is inconsistent with, now this is so important, with the normal development of a human being of the minor's sex, including abnormalities caused by medically verifiable disorder of sex development, but does not include gender dysphoria, gender identity disorder, gender incongruence, or any mental condition, disorder, disability, or abnormality. I might have included the words or any other, so it's a civil statute. So somebody will go, well, what about this word? You didn't include this word, so it's okay. Well, just use words in general that generally describe what it is we're dealing with here. But now this is legit. So my approach would have been to say absolutely, or categorically at least, that it is prohibited to maim children. That's it. There's a prohibition to take any surgical procedure unless, with the exception that. So if it's a congenital physical abnormality, it's, their XY chromosome is normal. XX chromosome is normal. And in that development, was there a mutilation of their genitalia from birth? Was it an unnatural or defective growth that caused mutilation in their genitalia? Then you can make an exception for plastic surgery or whatever. And I've heard of somebody, and it's actually, I just know of a story, so it's secondhand. So I know of somebody who has a firsthand account on somebody who is a boy, was an XY chromosome, but had disformed genitalia. So they did this Dr. Mengele treatment on the young man, on the young boy, changing and mutilating his genitalia because the parents feared of the stigma that the child might have as they're growing, that their genitalia isn't like everybody else's, or their genitalia is dysfunctional. Well, guess what? Changing the genitalia to make it look like it's a girl is still not functional. But the parents and the doctors took it upon themselves to morph the boy into the girl, tell the boy he's a girl, give the boy hormones as a treatment to get the boy to more likely feel like he's a girl. And guess what? He grew up and he realized, I am not a girl. I am a boy. I'm an XY chromosome. So the man who had been raised as a girl because of this Dr. Mengele approach to treating a situation, he basically changes identity to a man. Guess what he is? He's a man. He stopped taking the dysfunction hormones, and his genitalia are disformed. They were disformed from birth, but carving him up to make him look like a girl, tell him he's a girl, and all these kind of things. That would be a legitimate, let's say, gender identity. That is a legitimate gender identity change because somebody manipulated the boy's body, just like the U.S. Department of Justice would have people do, to tell him, to convince him that he was a girl. And some people convince themselves that they're a girl. In that case, it's dysphoria. And I think in the parents' case of this man was dysphoria. So here's what the legislature thinks is the definition of sex. It means a person's immutable characteristics of the reproductive system that define the individual as male or female as determined by anatomy and genetics existing at the time of birth. Now, they could have shortened that quickly. They could have said genetics. The genetics aren't going to change. You're either XY or XX. So this kind of, I don't know if this is the best approach to this kind of a statute. I think it's got some could use some cleaning up, but nonetheless, Tennessee, keep this in mind and communicate to your legislature based on the things we've talked about here. What are the absolute rights of the individual? In fact, when you write your legislator, you can quote Blackstone. So go to Blackstone's Absolute Rights of Mankind, read it, take notes, quote it, cite pages and all those things. Read his book on parent and child, and read that understanding that the duties in law that's absolutely natural for the parent's rights and duty to protect the children and to treat them in a way that, say, the Department of Justice, which is a misnomer. It is, I'm just over and over again, I'm seeing continually, it's a Department of Injustice. In fact, if there's an injustice happening, the Department of Justice fights hard to protect the injustice from any correction. So you've got to, I know this because I'm suing the United States right now, and I'm appalled. I'm absolutely appalled. I don't know why these lawyers don't lose their license to do things, because the amount of lies, obviously they're trying to take legal maneuvering. They'll try to utilize the rules in their favor and try to encourage the court to ignore the rules when they protect you, but they'll actually lie. They'll manufacture things. They'll do things that are completely just evil, leading to injustice. And you've got to be really on your game to overcome the hard work with taxpayer monies to lead to injustice. That's what I'm observing with the Department of Justice. Now, I don't know that it had been like this in the last 50 years. I don't know. I'm just saying what I've observed here, actually for myself, in the last 20. So here's a prohibition. Healthcare provider shall not perform or offer to perform on a minor or administer or offer to administer to a minor a medical procedure if the performance of administration of the procedures for the purpose of. Now, see, I would have not written it that way. I would have said you may not do these procedures of this prohibition unless it falls within the particular exception. So I would have done a positive statute saying it is unlawful, this prohibition, you may not maim children with this exception. But here it says, for the purpose of enabling a minor to identify with or live as a purported identity consistent with a minor's sex. Because the issue is that your procedures are not codependent to dysphoria. That's supposedly the object here. They also go on to say, for treating purported discomfort or distress from discordance between the minor's sex and asserted identity. But see that how loose that is? Well, what about anti-anxiety medication? Does it include anti-anxiety medication? Are you excluding anti-anxiety medication to somebody who's in gender dysphoria, where you wouldn't give anti-anxiety medication for somebody who had a different dysphoria of their teenage years? So I think this is written badly. I appreciate their zeal, and I think they're wound up, but I think I don't know who it is coaching them on this, but it's my opinion. So let's keep on going. It is not a violation of subsection A if the healthcare provider performs or alters, does something like this, the performance of such and such to treat a minor's congenital defect, disease, or physical injury. Well, that's good. Now that's exactly what I thought they should be saying. The performance of such as. Oh yeah, and then they have this thing. This is really, again, this is part of civil law. It says the performance or administration of the medical procedure on the minor began prior to the effective date of this act. So they can get away with it up until the act. And that goes back to there shall be no law ex post facto. You got to tell somebody beforehand that their procedure is actually violating the law, because it's not fair. It's unjust to not give them fair warning. So this definition here, it says disease does not include gender dysphoria, gender identity disorder, gender incongruence, or any mental condition, disorder, disability, or abnormality. So that's the important crux of this statute is you're not performing surgery on minors that because of their dysphoria. It does not justify the maiming of anybody. And nobody has a right, not a parent nor the state, to intervene and to not protect the child from their own temporary insanity. Testing 1 2. I'm getting nothing on live chat.